Hello everyone, welcome to Indian Judicial Service. Today we are discussing here the Indian Contract Act 1872. This video is the 14th video of top 300 MCQ of Indian Contract Act video series. If you are not watched the previous video, all the link of previous videos are available in our description box. You may watch these videos through the links. And if anybody wants the PDF file of this video series, the PDF file will be available in our WhatsApp and Telegram group. And the link of Telegram and WhatsApp group is also available in our description box. You may join through the link. And before starting this video, I request you please like our videos, and if you are not subscribed it, please subscribe our channel. Let's come to the point. Question number 191. A continuing guarantee apply to. So first of all, the continuing guarantee is available in our Indian Contract Act under section 129. Section 129 dealing with the continuing guarantee. So continuing guarantee means which extend to series of transaction. So which extend the series of transaction is called continuing guarantee. So it is related to the series of transaction. So series of transaction is called continuing guarantee, and it is available in section 129. Now option A here is specific transaction, option B here specific number of transactions, option C here any number of transactions, and option D here reasonable number of transactions. So the continuing guarantee apply to a specific number of transactions. So answer of this question is option B. Now question number 192. A continuing guarantee under section 130 is option A revocable absolutely, option B irrevocable absolutely, option C revocable as regard the future transaction, and option D either A or B. So according to the section 130, this 130 will dealing with the revocation of continuing guarantee. So 130 dealing with the continuing guarantee may at any time. So at any time of revoke by surety as to future transaction by notice to the creditor. So it revoke at any time. So now come to the question here. So option A here revocable absolutely, option B irrevocable absolutely. So it is revocable. So option C revocable as regard the future transaction, and option D either A or B. So it is clear here. Our answer is option C. According to section 30, section 30 dealing with the as revocation continuing so far as regard the future transaction. So answer here option C. Now question number 193. The liability of surety on his death under section 131 in case of continuing guarantee. So first of all we discuss section 131. So section 131 dealing with the revocation of continuing guarantee by surety's death. So the death of surety operate in the absence of any contract contrary as the revocation of continuing guarantee so far as regard future transaction. So it is so far as regard future transaction. So now come to the question here. Option A, it terminate absolutely. Now option B, does not stand determined as regard past transaction. Option C here, the stand terminated as regard future transaction, and option D both B and C. So it is clear here the revocation of continuing guarantee by death of sureties. So in that case the revocation continuing guarantee so far as future transaction. So answer here option C. Now come to question number 194. The surety stand discharged. Option A by revocation, option B by death, option C by variance in term of contract without his consent, and option D A, B and C above. So it is clear here the surety stand discharged according to section 133. Section 133 dealing with the surety when discharged, the variance of in terms of contract without consent. So if the terms of contract is changed by the principal, debtor and creditor without the consent of surety, in that case the surety is discharged from the contract and the performance of the contract. So this thing is provided in section 133. Section 133 clearly dealing with the variance and made without surety's consent in term of the contract between the principal, debtor and creditor that discharge the sureties as the transaction subsequent to the variance. So answer of this question is option C according to section 133. Now question number 195. Under the Contract Act guarantee, a creditor, option A, has availed his remedies first against the principal debtor. Option B, can avail his remedy against the principal debtor as well as surety. Option C, can avail his remedy against the surety alone. And option D, both B and C. So it is clear here, the contract of guarantee, a creditor has availed his remedy first against principal debtor, and if principal debtor is fail to pay or to perform his contract, then the liability of sureties rises. So answer of this question is option A. Question number 196. The surety stand discharged. So option A here, by agreement between the creditor and principal debtor. Option B here, an agreement between the creditor and third party for not sue the principal debtor. Option C here, both A and B above, and option D here, neither A nor B. So according to section 133, the discharge of surety by variance in term of contract, and so the terms of contract between the principal debtors and creditor, but they are not informed and they are not get the consent of the surety, then the surety is discharged as to the transaction subsequent to the variance. So this thing is provided in section 133. So now the surety stand discharged by the agreement between creditor and principal debtor. So answer of this question is option A. Now question number 197. Under the contract of guarantee, if the principal debtor is not liable, the guarantor is not liable. Option B, if the principal debtor is not liable, the guarantor is liable. Option C, if principal debtor is liable, the guarantor is liable. And option D, all of the above. So according to this question, under the contract of guarantee, if principal debtor is liable, the guarantor is liable. So answer is here option C, because the principal debtor is liable, the guarantor is also liable. But when the principal debtor is a failure to perform their contract, and then the liability of the guarantor is arises, and so in that time the guarantor should pay and perform the contract. So answer here option C. Now question number 198. In contract of guarantee, so in previous video, we discussed very widely the contract of guarantee and contract of indemnity. So option A here, there are the two parties. So in contract there are not two parties, there are three parties. So option B here, there are two parties and two contract. Option C here, there are the three parties, three contracts. So it is also wrong here, there are three parties, but there is only one contract between these parties. So this statement is also wrong here. Option D here, there are three parties and one contract. Yes, this statement is correct here. The contract of guarantee has three parties and one contract. And what are the three parties there? First one is the principal debtor, second one is the sureties, and third one is the creditor. So these are the three parties of the contract of guarantee. So answer of this question is option D. Now question number 199, and this thing is provided in section 126 clearly. Now question number 199. In case of co-sureties, the release of one surety by creditor. So this question is directly related to section 138. Section 138 dealing with the release of one co-sureties does not discharge other. Means when the release of one co-sureties by the creditor, the other remain sureties are not discharged. So this thing is provided in section 138. Now option A, amount one sureties by creditor. The option A, amount to discharge of other sureties. Option B here, does not amount to discharge the other surety. Option C, amount to discharge of surety. So release vis co-sureties as well. And option D, none of the above. So it is clear here, other sureties are not amount to discharge here. So option B, does not amount the discharge of other surety. Now question number 200. On payment or performance of liability, the surety. So this question is related to section 140. Section 140. Section 140 dealing with the right of surety on the payment of performance. Now we discuss these options here. So section 140 dealing with the right of surety on payment or performance. So in case of Allahabad AIR 1927, it is clear the Allahabad High Court described that the sureties getting the entitled all the right which belong to the creditor against the principal debtor. When the sureties are on payment or performance of the contract on the behalf of the principal debtor, then the surety getting all the right of creditor and who belong to the creditor against the principal debtor. So this thing is provided in section 140. Now option A is invested in all the rights the creditor had against the principal debtor. So this option is most appropriate here. So answer is option A, and remain option B, entitled the every sureties and which the creditor has against the principal debtor. So this is not here correct here, and option C here is entitled to indemnify by the principal debtor, and option D all of the above. So it is clear here according to section 40 the sureties is invested with all the rights the creditor had against the principal debtor. So answer is here option A. Now question number 201. The surety is entitled to be indemnified by the principal debtor. This question is related to section 145. So section 145 dealing with the implied promise to indemnify surety. So in every contract of guarantee there is an implied promise by the principal debtor to the indemnify surety. The surety is entitled to recover from, so here surety is entitled to recover from principal debtor whatever sum has rightfully paid. This is very important here. He has rightfully paid under guarantee, but no sum which he has paid wrongfully. So this thing is provided in section 145. Now come to our question. So question is here, the surety is entitled to indemnified by the principal debtor. Option A in respect of sum rightfully paid. Option B here in respect of sum wrongfully paid. Option C here in respect of sum paid rightfully or wrongfully, and option D all of the above. So according to section 145, the surety is entitled to indemnify by the principal debtor in respect of sum rightfully paid. So answer is here option A, not for wrongfully paid. He is not entitled to recover his amount or sum for wrongfully paid. He is only in respect of sum rightfully paid. So option A. Now come to question number 202. Under section 146, the co-sureties are liable to contribute. So section 146 dealing with co-sureties liable to contribute equally. So this thing is provided in section 146. Now option A equally, option B unequally, option C according to their capacity, and option D either A, B and C. So section 146 dealing with the co-sureties are liable to contribute equally. So answer is here option A. Question number 203. If co-sureties are bound in different sum, they are liable to pay. Option A equally subject to the limit of their respective obligation. Option B equally without any limit. Option C equally irrespective of their obligation but subject to the limit. Option D either B or C. So option A is correct here, because if the co-sureties are bound in different sum, they are liable to pay equally subject to the limit of their respective obligation, and this thing is clearly provided in section 147. 147 dealing with the liability of co-sureties bound in different sum. So in that time the liable to pay equally as far as the limit of their respective obligation permit. So this thing is provided in section 147. So answer of this question is option A. Now question number 204. The surety on the payment or performance of his liability against the principal debtor. Option A has right to subrogation. Option B has right like creditor had against the principal debtor. Option C both A and B, and option D either A or B. So it is clear here answer option B. The surety on payment or performance of his liability against the principal debtor has right like creditor had against the principal debtor according to which section? According to section 140. So next question here, 205, bailment involved. So we are not discuss this question here because this is another new topic in bailment, and so bailment we discuss in next video because the bailment is extended to section 148 to 181. So this topic is also very important in the chapter 9 of the Contract Act. So in next video we discuss the who is bailee and bailer and bailment, all these terms, and we will continue this topic in next video. Now finish this video, and if you like this video, please click on like button. If you are not subscribed our channel, please subscribe it, and thank you for watching Indian Judicial Service.